a coffee topic this morning. I have a good one for you. This was a case that involved workplace violence, unfortunately, and a security guard was killed as well as a patron at a mall. And what happened was OSHA cited the security company for failure to implement policies and procedures for workplace violence, and they were cited under the general duty clause. And I'll have to pull up the actual case because it's important to understand where I'm going with this. What happened was, under the general duty clause, OSHA found that the attacker was the threat, was the hazard, workplace hazard. What happened after that with the citation was the company actually contested it. It went to an administrative law judge, and the administrative law judge tossed it out and said in the decision that the actual hazard, the attacker, was not cognizant to the OSHA standards, meaning OSHA doesn't recognize. So cognizant was it's not recognizable. OSHA doesn't recognize the attacker in the standard. So there was no way the standard could apply to a non employee or a non workplace situation. This is interesting. And also that the threat, the violence, was idiosyncratic in nature, meaning idiosyncratic is, for those who have to, those of us who have to look this up, it was uniquely, it presented itself uniquely. It was unique to that individual. It wasn't, it didn't arise out of the workplace. It wasn't inherent to the workplace. And so threw it all out. They also found that the security company did in fact train security guards to a standard, an industry accepted standard to deal with workplace violence. And their job was to confront people who were being threatening, unruly, disruptive things. And they were trained in methodologies and methods for de-escalation, things like that. This individual just chose to come in with a gun and start shooting people. And so this brings up a great question. Now we have precedent with this judgment. Brings up a good question about any past cases that, is there any recourse? I don't know if you can go backwards, but certainly going forwards, I've always found it odd that you could have an employer be held responsible by OSHA for an outside actor whom you have no knowledge or no control over decides to come into your workplace, whether it's the workplace is in a public environment or public setting or access to the public. So now we know that one, that OSHA doesn't recognize those individuals, can't apply, the standards can't apply to those individuals. And then two, it is idiosyncratic in nature, meaning the threat itself, the hazard, did not arise as a result of the work environment. Okay, so now follow this logic. Could this, do you all think, could this also apply to even employees or former employees? What about employees, spouses, significant others, partners? Maybe there's a dispute, they're having a personal dispute or grudge, and they come back they know where this individual works, and they choose to come from the outside. They come to this workplace. The workplace has policies and procedures, they do training, but maybe it's just an office environment. They're not dealing with law enforcement or security or personal protection or anything like that, so they're not even uniquely qualified in this space, but they have policies and procedures that would be generally accepted as, okay, this is about as much as you could do. Do you see this not being pushed anymore going forward by OSHA onto companies that did nothing to actually bring this about, but also have no practical way of knowing when and where and who would be doing these things. It's tough. It's a tough situation. Again, I'm trying to isolate this down to just sort of this workplace safety, regulatorily speaking, workplace safety context. They're all tragic. It's horrible. It's absolutely terrible. But I've kind of had this opinion for years that it's just adding insult to injury that you go through this tragedy, and workplaces might go through this tragedy, and dealing with the loss of workers and just feeling violated at work, in that way, in such a violent way. And then here comes the federal government saying, oh yeah, and now it sends a message to the workers. Your employer should have been able to stop this or should have done something about this. What? Like, how? So basically that puts your employer, everything they do is now defense, meaning they're just going to assume you and every other worker is just one day going to come in and start shooting the place up. So we're going to treat you as such. It's terrible. Absolutely terrible. So, terrible all around. There's no answer. Look, this is one of those things where from a practicality standpoint, there is only so much you can do with that's practicable, right? ALARP comes to mind, as low as reasonably practicable. I mean, I'm not going to be able to put personal security guards at every entrance and put bars on all the windows and put concrete barriers, 50 yards out around the building to keep cars from driving up to, like, and it's a small tool and die shop with 12 employees. There's this consideration that has to be made as to, like, what is foreseeable. And even if it is foreseeable, you could say, well, yeah, a meteor could fall out of the sky. That's foreseeable. I could foresee that happening, I guess. Why don't I have a dome over my building to prevent that from coming into the building and injuring my workers? I mean, I know I'm kind of being silly, but that's kind of how silly some of this stuff gets in the terms of, like, some outside actor has an ideation for some reason against your business or in general, and they just happen to pick your business because it was convenient and they want to stream something live, and they're just angry. They're just a broken human. And here comes OSHA and says, oh yeah, you should have figured that was going to happen. You should have had some training on how to deal with bullets flying at you. I'm being silly about it, but for a good reason. I want to know what your thoughts are. What is practical? Or practicable, I should say, for employers to do? And do most employers do that? I think they do. Having policies, procedures, see something, say something, report, where behavior such as this and that. I mean, outside of that, what are you going to do? I want to hear your thoughts. What do you think about the case? Do you think it changes things going forward as far as how OSHA is going to approach employers when it comes to workplace violence? They're going to take a longer, harder look at whether or not they should be issuing general duty clause citations. And again, general duty clause citations, because there is no workplace violence. Not yet anyway. There's not a standard. There might be one coming soon. We'll see. But what do you think about OSHA's response? And then the other piece, of course, is what is practicable? Do you think companies can do better in this area? Where's that balance? All right. I look forward to reading your replies.